I think it's going to be challenging because if race as a contingent component of university admission applications cannot be used, then that will mean that a large section of applicants that are either African American or Latino or Latina will be excluded from particularly these highly selective universities. So it's going to be really interesting because what the Roberts Court has done is essentially to say that uh, using race as one of the contingent factors in determining admission is inherently discriminatory based on the 14th Amendment, the Equal Protection Clause. But then supporters of affirmative action really say that we really need to have a holistic view before we determine an admission based on an individual's prior experience, upbringing, and race. Those should also be factored in. So the court is really going to increase these inequalities because fewer minorities are going to get admission to these highly selective universities.
David, the affirmative action and the race-conscious admissions have been in place from the Supreme Court for just about 50 years now. What do you think prompted a change in this, the action that was taken yesterday?
I think it's partly due to the new composition of the court. We have a lot of new conservative justices that have made it to the Supreme Court, particularly during the Trump administration. We've had traditional skeptics to race as a factor in admission, particularly Clarence Thomas, the African-American Supreme Court justice. But let me also remind your audience that previously in the decision in Baca versus University of California, Davis, there was a challenge to racial admissions, which was upheld, racial quotas. And more recently, in the case of Fisher versus University of Texas, the Supreme Court upheld the use of affirmative action in terms of admissions and use of race. So this decision by the Roberts Court actually is a very conservative decision. And I think you can actually see that read within the dissenting opinion of the justices that didn't agree with the majority, who said that just because the court does not recognize race in law, it doesn't mean that race and racism does not exist outside of the courtroom. In other words, the court's color blindness look on how it interpreted this case doesn't negate the fact that race is an important component and a barrier to minority students accessing university education.
David, thanks. We'll see how colleges are going to adjust how the admissions are carried out forward. David Monda is a professor at City University of New York.